First Amendment to the United States Constitution includes that Congress shall make no law abridging the freedom of speech or of the press. Notably, defamation is not protected by the First Amendment. The elements for defamation are 1. Publication, 2. Falsity, 3. That the defendant acted with knowledge or reckless disregard as to the falsity on a matter concerning a public official, or at least negligently on a matter concerning a private person. 4. Actual damages, and 5. The statement must be defamatory. The 2024 Florida legislative session began on January 9th of this year and recently concluded on March 8th. Hundreds of bills did not pass. One of those bills was House Bill 757, which would have made significant changes to the defamation law in Florida. The bill sought to address a key ruling from the United States Supreme Court in a case called New York Times versus Sullivan. In that case, where the court held that if a plaintiff in a defamation case is a public official, they must also prove that the statement was made with actual malice, meaning the defendant either knew that the statement was false or recklessly disregarded whether it might be false. So the bill, if passed, would have presumed actual malice if a public figure proves that a statement was attributed to an anonymous source and that statement was false. House Bill 757 also revived the tort of false light in the limited context of the intentional use of artificial intelligence to create or edit any form of media. Now, in 2008, the Florida Supreme Court, in a case called Jews for Jesus Inc. versus Rap, declined to recognize the tort of false light. So the bill also would have included a broad venue provision for filing defamation suits. So where the broadcast was through the radio or television, venue would be proper in any county where the material was accessed and in which the plaintiff reasonably suffered damages as a result of the broadcast. Where the defamation was published through the internet, venue would be proper in any county in the state which the plaintiff reasonably suffered damages as a result of the publication. This was the second year in a row in which changes to defamation law had failed in the Florida legislature. It's noteworthy back in 2023, the bill at that time would have included, quote, an allegation that the plaintiff had discriminated against another person or group because of their race, sex, sexual orientation, or gender identity constituted defamation per se, end quote. And where there's defamation per se, malice and damages are generally presumed as a matter of law, and they do not need to be proved. The presumptions may justify punitive damages award, even where the jury does not find the plaintiff suffered actual damages. So in the last 2 years, defamation law changes have failed in the Florida legislature. We'll have to stay tuned for next year to see if another bill will be filed to seek to further modify defamation law. Thanks.